everyone. Welcome to the first in a long time Immigration Section MCLE. My name is Joanne Litt, and my co-chair is Maggie Stewart, also over there. And we're the new co-chairs of the revived Immigration Section, and we have planned some interesting topics for the next couple of months. We want the section to be not just about education on timely issues, but we also want to bring in other sections with different topics that are of interest to both, lawyers who practice in both areas or lawyers who sort of see issues in other areas, including immigration. And we want to have more of a local focus instead of like Ayla's focus is very national and on broader topics, but we're hoping that this section is going to be more focused on the needs and practice interests of our community in the local LA, Southern California region. And so what we have upcoming in July, we're going to have a MCLE on EB-5 and investor, immigrant and non-immigrant visas. And for the rest of the year, we have topics on immigration and criminal law, entertainment and immigration law, and hopefully we're going to do a deep dive into asylum once kind of this administration's asylum stuff settles down. And I was told to remind everyone that the MCLE credit certificate will be mailed out within 24 hours. And to join the section, and there's a section and there's an online community, I think it's being posted in the chat on how to do both. And we're hoping to have monthly meetings of the section on the second Friday so that people can network, people can discuss topics or bring up speakers that they want to see or other issues that, people are interested in going deeper down, and we can hopefully provide more content in that vein. And so now I'm going to pass it to Maggie to introduce our speaker. Thank you.
Thank you, Joanne, and welcome to everyone who's logging in. I'm going to take a minute to introduce our speaker, Jonathan, and watch. Hopefully everyone who's planning to be here today will get a chance to log in. As Joanne mentioned, if you look in the chat bar, you'll see links. One is for a link to join this section so that you can be sure to be part of the news and planning going forward. The second link is to join the immigration community, an online forum where we can get together and discuss immigration related questions and look for tips and tricks and places to go and maybe pull our hair out with friends and colleagues. So happy Friday and welcome. I'm very pleased to introduce our immigration law colleague, Jonathan Kantor. He is an attorney at the law office of Eli Kantor, located in Beverly Hills. He was admitted to the California bar in 2016 and has an undergraduate degree from UCSB in literature. He graduated from UCLA School of Law in 2016. Jonathan has an extensive background in all aspects of immigration law, having worked at the law offices of Judith Wood during college and now at the law offices of Eli M. Kantor. He has special expertise in obtaining green cards for DJs and O1 visas for entertainers, as well as social media content creators. He also works on marriage and citizenship cases and attends their interviews at immigration. Jonathan is a chair of the Beverly Hills Bar Outreach Committee, along with Gina Kang, and is a member of the Beverly Hills Bar Network Committee. Today, Jonathan's going to be joining us to discuss the immigration laws and practice under the Biden administration. Specifically, he's going to be looking at the bill that's currently in front of Congress, and also sharing with us his more recent experiences sort of on the ground with applications and processing. You are welcome to please post questions in the Q&A. Some of the questions will be put to Jonathan as he goes. Some of them we may hold until the end. So if your question didn't get answered right away, don't worry, we will get to it. And we do encourage you to be interactive and participating. We have about an hour scheduled, so we'll be going forward till about 1:30. And I hope that you will join the section and join the community, and that this is the first of a robust immigration section at BHBA. Take it away, Jonathan.
Thank you, Maggie, and thank you, Joanne, for having me here, and thank you, Alex, for administering this. Okay, I'm going to start off first with Biden's accomplishments in the first 100 days in office. Quick disclaimer, I'm going to be talking about asylum and deportation updates. I don't practice those areas of law. I'm not an expert. So if you have those questions, I advise for you to ask them to a specialist. Biden's first major move in terms of immigration is the U.S. Citizenship Act of 2021, which will create a pathway for citizenship for 11 million undocumented individuals. He introduced this bill in his first week as president, and I will go into it a little bit more later on in the program, but I would say it's high priority because it was one of the first bills that was introduced to Congress. The other thing he did was he rescinded the travel ban and the refugee ban, and so that affected countries such as Iran, Somalia, Sudan, Nigeria, North Korea, and Venezuela, and other countries. How that affected me in practice was the last 4 years, a lot of people would call from those countries, and unless they had an immediate relative, which would be either a child or a spouse or a parent who was a US citizen, I was unable to help people from those countries. And so that is a major move that's going to be helping a lot of people from those countries now have a chance to come back to the US. He also got rid of the public charge rule and eliminated Form I-944. Essentially, that was a form where you had to prove that you as an immigrant coming into the country, trying to gain a green card, would not go on welfare. It was a very tedious form. I would kind of compare it almost to filling out a mortgage application. You had to put a credit score, all your assets, transcripts from educational schools, and it was also tricky to fill out. I think it maybe lasted, I would say, less than a year. And so, yeah, now when you apply to adjust the status to a green card, you do not need that form. You still need to prove that you won't go on welfare by filling out a Form I-864 affidavit of support, where you have a sponsor who can show that they have U.S. tax returns that is above, it's around 100 to 200% above the federal poverty line. The next thing he did was he repealed the ban on non-immigrants for an H-1B, L-1, and J-1 visa. And he also repealed the ban on immigrants and non-immigrants who represent a risk to the US labor market. He extended Trump's travel ban on immigrants from the UK, Ireland, the Schengen countries, which consists of Europe, China, Brazil, and he established a new ban from South Africa due to the variant in the novel coronavirus. He established temporary restrictions on travel from Canada and Mexico, which have been extended to May 21st, 2021. The ban is not absolute. If you are married to a US citizen or you're a green card holder, you can come, I think, provided you show proof of I want to say a negative COVID-19 test. And there's also a form called the National Interest Exemption, where you file it with the Consumer Protections Bureau, stating that you have to come to the state in a matter of great national interest and importance. A lot of entertainers are doing this. We currently have a client from the UK who I believe will probably have to fill this out for him unless Biden moves the travel ban from the UK. In other news, carrying along, the Department of State is allowing certain citizens subject to regional COVID-19 bans with valid visas to travel to the US. Next, he agreed to stop the blank space rejection policy. So what was happening was, I think it was right after quarantine around the summer, USCIS was returning applications to law firms and petitioners, and they were returning the entire application along with the check. It wasn't because it was addressed to an incorrect address. It wasn't because the money on the check was incorrect. It was because you left a blank space on a form, even though that question didn't necessarily apply to your case. So I think the LA County Bar Immigration Section were going to resort to legal action. I don't know if they filed a class action. We were just pretty much advising our friends, and when we were doing the applications on our own, we were just saying not applicable on each line, and it's only happened to us once. I would advise practitioners going forward. Sometimes immigration is tricky like that, and if you can, say not applicable. But they've said they've stopped the blank space rejection policy, so hopefully we don't see this occur in the future. Regarding naturalization, the citizenship test. So Trump had changed the 2008 civics test to make it more difficult and ask more questions about the Constitution and US history. USCIS has announced that it will go back to the 2008 civics test for the N400. And President Biden has requested resources to help out with the naturalization backlog. In terms of how this happened in practice, I think we filed a N400 on behalf of two of our clients, a husband and wife. And first we told them to go online and review the new questions, but now we told them to go back to the 2008. So any practitioners out there, if you've advised them, your clients, to use the revised version, I would advise you to go back to the 2008 test. You can find this online. If you just Google USCIS N400, I would strongly advise all of you to have your clients practice the test beforehand. You have to get 6 questions out of 10 correct to pass. And if not, you're going to have to come back again for another N400 appointment. Biden administration has also scaled up capacity to address the increased numbers of unaccompanied minor children seeking protection. And this is something I'm going to address in terms of the optics of the U.S. Citizenship Act of 2021. The administration has announced that they will not have funding for border wall construction. Biden has announced he will increase the refugee settlement to 62,500. He has created a task force to reunite families separated under zero tolerance. And lastly, he has amended and extended temporary protected status, also known as TPS, for residents of Burma, Syria, Venezuela. It is essentially a type of temporary status that citizens of this country can apply for, whereby they show that because of political unrest in their current countries, they need to remain in the U.S. until that unrest becomes more peaceful.
So Rich Walton has asked, what changes, if any, have been made to marriage visas for out-of-status spouses due to COVID-19?
So if you are out of status and you have overstayed a visa, if you marry a U.S. citizen, that forgives all the time you've been out of status. So that would be my answer to that question. This is something that's been going on ever since I was admitted to the bar, even before then. And this isn't new with the coronavirus.
To confirm, so simply the act of getting legally married would cure the out of status, and then they would proceed with an adjustment of status or a new application after that?
Exactly.
Great,
Yep.
thank you.
But they have to have entered legally with a visa.
Exactly. Yeah.
Sometimes people think, oh, this person's undocumented and they can just marry, like on TV, that they think that they can just marry U.S. citizens. But if they entered without inspection, it doesn't work.
Exactly. Okay, now I want to look at the U.S. Citizenship Act of 2021. The bill will allow for undocumented individuals to apply for temporary legal status with the ability to apply for green cards after 5 years if they pass criminal and national security background checks and if they pay their taxes. When I say undocumented, that's a very large scope. I'm talking about people who entered without inspection and also people who have overstayed their visas, who've entered legally, but they've overstayed their visas. This will allow dreamers, temporary protected status holders, and immigrant farm workers who meet specific requirements. They'll be eligible for green cards under this legislation. And lastly, they can receive citizenship after 3 years. All green card holders who pass additional background checks and demonstrate knowledge of the English and U.S. civics test can apply to become citizens. The applicants must be physically present in the U.S. on or before January 1st, 2021. So how are you going to prove presence? I'm imagining if the bill gets passed, there will be some advice memos. But in terms of clients who've called me, who are in wait on potentially being able to benefit from this, I've told them to gather taxes, bills, receipts, obviously receipts from places in the US, mail, if you go to a gym, any entries. You have to just get creative. If you've been to a library, just proof that you entered the library and you checked out some books. The status of the bill is it's currently pending in Congress. And in terms of outcome, how will this be passed right away? When? How? In terms of priority right now, I think with both President Biden and Congress, economic recovery bills sound more pressing. I also think it's going to be very difficult to get all the votes for this bill as presently constructed due to the fact that there is the current migrant surge. And I think Congress and the executive branch wants to deal with that first and kind of smoothen that out. And I think it's also sort of hard to sell this bill while the surge continues to increase. However, that being said, I think this is something that's really important on Biden's agenda. I think that it can either be passed through piecemeal legislation, so parts might be passed and other parts might be removed. It may be revised. And lastly, there's always the executive order power, which obviously we know that Obama did with the DACA bill. When clients call, there's not really much I can tell them. I just tell them you have to wait and be patient. It's pending in Congress. But if this will be passed as stands, it will probably be the most comprehensive immigration bill since Reagan in amnesty of 1986. Maggie, any questions?
There are, so thanks for giving me a chance. So one is a follow-up to the earlier question about people who are out of status and married during COVID times. This is specifically, what if the person originally did not enter legally, did not have inspection?
Okay, so if they entered without inspection, then what you're going to have to do, assuming that that's their only entry and they haven't had several entries, what you're going to have to do is you're going to have to seek a waiver of hardship via the I-601. That is essentially a process where you have to prove that it would be a hardship to your spouse if you were have to return to your home country. And once you get that approved, then you can go through the whole adjustment of status process.
Practically speaking, what are the odds that somebody will succeed with the I-601 waiver for hardship? Is it a high bar or a low bar?
I would say it's a pretty high bar. You have to really show, first of all, country conditions, the danger of you going back. Usually something that really helps is if you have sort of health problems, if you're a diabetic, if you have severe psychological problems, and psychiatrists are really good at this. They can sort of write a very detailed report about sort of the family connection and why you are so important to that person. And then also you have to prove country conditions. So if the country you are originally from has good healthcare or good hospitals or is not dangerous, then I would say your chances of succeeding are less likely. But if you can prove that the healthcare in the country you're originally from is inadequate, and you need the health facilities in the U.S., then your chance of succeeding is higher. But I would say the bar is high, and also it depends on every case.
And so if someone doesn't succeed with their I-601 and they have to return to their home country to do the adjustment of status, do you have a rough idea how long that's taking from the time that, people leave till the time they're able to return?
I'm not sure about that because you also are going to have the problem of since you've accrued unlawful presence, you may be subject to a bar. So we have a client right now who we got his I-601 and then he applied in the embassy in Israel. And essentially they said, okay, your I-601 was good for when you entered without inspection, but the time that you overstayed your tourist visa and you kept asking for an extension, that was also another unlawful presence. And so because of that, he's facing a 10-year bar. So I believe if you get denied, you're probably going to get stuck in the country you applied for. So that's the risk with I-601.
Okay. All right. Thank you. And some other questions have come up over in the chat. So
Sure.
One question is specific to the citizenship test and about taking the citizenship test in Spanish. And they're wondering if it's true that a green card holder has to be a green card holder for 20 years before they're permitted to take the citizenship test in Spanish, or what would be when would someone be allowed to take the citizenship test in Spanish, if you know?
No, I understand the question. So what I would do is instead of taking it in Spanish, I would just bring an interpreter. And USCIS has rules. You cannot, I don't believe you can bring your spouse for the citizenship test. I know for I know for a fact for the marriage, for a marriage case, you cannot have your spouse interpret for you. You can bring a friend. Sometimes it depends on each officer. They kind of become a stickler, like, oh, I want to see your interpreter license. But I've done it where I think it was a citizenship case. It was a family based adjustment. It was a mother for her daughter, and we brought a friend to translate for the mother, and that was fine. Also, keep in mind all of the different offices, which I'm going to get to in my next section, have their own rules about how many people can be in the room. So some offices may say you need to call the interpreter. But in terms of, so the simple answer is, if you want to take the test in Spanish, just bring an interpreter. Make sure it's not a spouse and it's a friend, and they will just interpret each question from English to Spanish for you. They'll translate it.
There is that 50-20 rule, right? The 50-20 and the 55-15, that if you're over 50 and you've had your green card for 20 years, you can take it in Spanish. Or if you're 55 and over and you've had it for 15 years, you can take it in Spanish. But I think your way is better.
It's probably the smoother. Yeah.
And then we also had another question, and I'm not sure that I'm going to phrase this correctly. So Anat, if I get it wrong,
okay,
please jump in. It's can the Dreamers Act, which I think you're meaning like the route to citizenship, be applied to those who have overstayed because of COVID, such as snowbirds who came down presumably last winter and then stayed through 2020?
Yes, as long as they were present in the U.S. on or before January 1st, 2021. So if you came here and you overstayed because of the coronavirus, whether it be you couldn't go back to your country because it was the virus was really dangerous there, if this does pass in its current iteration, you would be able to have a path to citizenship.
So to confirm, a person, if they've come in, whether they've come in with status or without status, so whether they've been inspected or not, they've come in, they've now lost status through an overstay or other reason. But as long as they were present in the United States January 1st, 2021, if this bill is passed, they'll have the opportunity to apply for temporary legal status and then ability to apply for a green card after 5 years.
Yeah, and also
right?
I want to, yeah, it's correct. Sorry, I didn't also add, as long as also you don't have any tax issues or criminal issues.
Okay, so if there's people who are, currently without status and they're interested in getting themselves organized now so that they can demonstrate eligibility for this, what are, I think you were talking a bit about preparing documentation to show that they were physically present, and about paying taxes. So that would be making sure that people have their taxpayer numbers or social security numbers and are staying on top of their tax filing requirements. Is that right?
Yeah, pretty much. Very similar to marriage cases and citizenship cases. Whenever you apply for a marriage or a citizenship case, you have to make sure that you have, whether it's citizenship, you have to be making sure you pay taxes in the last 3 or 5 years. And whether it's marriage, you have to be making sure you paid taxes. With those cases, we usually advise clients, if they haven't paid taxes for certain years, pay back taxes and work out a deal with the IRS. And for those cases, sometimes we won't even file until taxes are straightened out. You don't want to go to immigration and all of a sudden they ask you, so let me see your last 5 years worth of taxes, and they say, oh, I only paid for the last 2 years. That's going to be a big problem. That could potentially jeopardize your case. So with with these people if they have if they need to make sure that they have not failed any tax requirement, and also in terms of documentation, I would suggest anything that can show presence. So if they had a lease, even receipts from restaurants and bars, you're gonna have to just kind of get creative with it. I was gonna add one more thing that I forgot to say. I'm imagining if this bill gets passed, President Biden will direct Mayorkas, who is the head of the DHS, to in turn put some memo on how to process this. It's probably going to be a separate form, not an I-485 form, and it's going to be particular to the people who fall in this category. And you're going to have to sort of answer, when did you enter the US, on what visa, or did you enter without inspection, your address for the last 5 years, whether you had a job, stuff like that. I obviously, I don't have a crystal ball, but I'm just kind of speculating on how the government would administer this form if this bill gets passed.
I would expect this is going to be, if it passes, a big opportunity for a large number of people. Do we have any sense? I mean, I guess the bill will pass, the application procedure will be set out. People will receive at some point after that their temporary status. And then once they receive their temporary status, they need to bank 5 years of residency under that status and then apply for their green card. Once they receive their temporary status, though, do we expect that they'll be able to leave and return to the United States to visit a home country or visit family, anything like that?
So that's a great question. With marriage cases, you can, right when you apply, you can file for a work permit, and you can also file for a travel document, which is called advance parole. Sorry, this is not only marriage. This is also for employment-based green card adjustment. The advance parole lets you do what you referred to, Maggie, go outside the country. I do not know if immigration is going to plan to do that. From what I recall with DACA, I do not believe if you receive DACA, I don't believe you're able to receive an advance parole. I think you're able to receive employment authorization. I do not know about receiving an advance parole. But that's going to be, these are logistics that are going to have to worked out between Department of Homeland Security and USCIS. Obviously, if the bill passes, to everyone listening out there, don't expect the form to be available right away. I think there's going to be several weeks and months working out the hurdles, preparing the form, and then also an advice memo on how to prove all you need to essentially have your temporary protected status approved by USCIS.
Great, that's all very helpful. We don't have any new questions just now, so I'll flip it back to you to continue with the presentation.
Cool. So obviously with the bill, we're very hopeful it could be a great breakthrough, and a lot of people could potentially become citizens, which is very exciting. I wanted to kind of talk to people about facts on the ground, what's going on in all the different USCIS locations. This is always fun for me when I'm talking to other lawyers, because they kind of sort of perceive immigration to just be like court, and it's not. It's much different than civil litigation or family law, or even criminal law. So there are several different locations in Southern California for where a immigrant and their spouse, or the immigrant themselves, or a green card holder will go to file a green card case or a citizenship case. I've been to the Los Angeles location, which is located downtown, and that's on 300 North Los Angeles Street. So right across the courthouses and the federal courthouses, right in the heart of LA. And that is most of the LA cases, I would say. If you live in the Valley, I would say more north, because I had a client who lived in Studio City and they still got the Los Angeles location. But if you live more north towards Chatsworth, or like 10 minutes between Chatsworth, you'll get your case sent down there, which I've been to the Chatsworth building. I personally like it much more. It's much smoother. There isn't a crazy line. Also, they're much more technologically advanced. Like I remember they were the first ones who had iPads, and then everyone else started getting iPads after them. And then if you live in the OC, you're probably going to go to the Santa Ana location. And I know that there's also a San Bernardino location. I haven't been to it. I believe the supervising attorney at my firm has been there before. And so what is sort of the procedure when you have a green card case or a citizenship case? More for green cards than citizenship case. With green card cases, the moment you get your interview notice, which they are very short in advance, they'll probably tell you anywhere from 2 weeks to 3 weeks in advance when your interview is coming up. I highly recommend that you schedule an interview with your client a week before, at least a week or 2 weeks before. And that interview is really important, especially for marriage cases, because you have to get the joint documents. And I can't tell you how difficult that is. With almost all of my cases, they always have some excuse about, well, I don't have a social security number, so I couldn't get health insurance, or I don't have a social security number, so I couldn't get a joint checking account. And you just really have to be strong with your clients about getting joint documents. You want to get joint life insurance, you want to get joint checking, you want to get joint health insurance. And, a lot of times it can become very confrontational, and your clients are going to get upset at you and they're going to say, well, no, this is ridiculous. We don't need all this. But no, you do. The interviews are very intrusive. The officers want to see these papers. Number one, to prove the validity of the marriage. Number two, they have to show it to their supervisors who are looking at the case. They need to see paper. You have to get those documents. And so you want to schedule this interview in advance, because it takes time. It takes time to get a life insurance, joint life insurance. It takes time to put your spouse on your joint utility bills. And so I would advise all practitioners, or anyone who's going to be a future practitioner, you want to, dedicate a good hour or two just preparing them. And then you want to get their phone number, obviously, and remind them to arrive early to their interview, whether it's a citizenship or a marriage interview, because the security line is really long. The 300 North one, I mean, sometimes it's all the way around the block, especially if it's a morning appointment. And also you have to take your shoes off, take your belt off, all that stuff. And then you kind of want to prepare your client about how the interview is going to go. It's very unorthodox. It's a little bit of an interrogation sometimes. It depends on what officers you have. Some of the officers have really thick accents. It's very sort of difficult to understand some of the questions. So you want to make sure that you understand the question, and you want to pause before answering. We have the 3 rules. Listen to the question, pause before answering, don't volunteer anything unnecessary. All of a sudden, an officer asks you if you've ever been out of status, and you say yes because you didn't understand the question, and you're looking at potentially being in trouble. And I would always advise my clients, you don't understand the question. Some of these questions they don't really make any sense. They're poorly worded on the forms. Just say, officer, I don't understand the question. Can you ask it in another way? Can you repeat the question? Advise your clients, especially for marriage cases, not to dress flashy. Try to dress conservatively. Dress like you're going to a court proceeding or city hall, something like that. And the last thing that's always very important, I would say the last 10 times I've been at a USCIS office, maybe only 2 out of the 10 times will I get a decision from the officer that day. So you always want to get something in writing. You want to get something that the officer says, essentially results of the interview. Sometimes if it's a citizenship case, it'll say you passed your civics test. This case is currently under review. If it's a marriage case, it'll say you've been granted your I-130, but your case is currently under review. And I would say this is very frequent with a lot of cases. You're very lucky. I've had it where you get approved that day, but you're very lucky to have that happen. I don't know why officers do this. I think it's probably because they want their supervisors to review the file and they want to be very thorough and make sure they didn't miss anything. That paper is very important because a lot of times, which I've dealt with a lot in the last year, you're going to have sort of a bureaucratic lag time where I had a marriage case where we didn't get a response from it for a year. And you need that paper because whenever you call up the USCIS headquarters, you have to present to them or tell them what happened based on the paper and give them a procedural history. If any of you are facing backlogs, I would suggest you call at least once a month. You can always escalate your call to have an officer call you. You can ask for an inquiry. You can tell them it's outside the processing time. And if they are really lagging a lot, you can sue the government and file a writ of mandamus. That's kind of a complex procedure. You have to serve the U.S. attorney and sort of show that there's a burden. Sometimes they're successful, but they're timely and they're expensive. And so I would advise anyone who's sort of dealing with bureaucratic lag times with their clients, just tell your clients to be patient. It's not you, it's the government, it's USCIS. They have a lot of files and they're backed up. But yeah, last thing I'll say with 300 North, note it's not a court proceeding. So it's a little bit different. You can't necessarily object to the questions that the officers are asking. I've seen some stuff on the LA County Bar Immigration Listserv that says you can file complaints if the officer does something inappropriately. I don't know how far that'll get you. They carry wide discretion in terms of their decision making, but prepare your client. You want to find out everything beforehand. This is the time. The week before is when it's when the attorney-client privilege is the most important, because you need to find out if they have any criminal problems, or if they have any tax problems, or if they have any family members who have criminal problems, or if they have any friends who are friends with them who are put in secondary. I can't tell you how many surprises I'll have in an interview. I was in an interview once where all of a sudden, out of the blue, they ask, have you or any of your immediate relatives been arrested for drugs, smuggling, or drug solicitation? And all of a sudden my client says, yes, my brother. It's news. First time ever. And unfortunately, his brother doesn't count as immediate relative. Under immigration's definition, immediate relative is your parent or your child. But this threw it in a whole bureaucratic nightmare. So I thought I had gone over everything, but still, like, I wouldn't say get into an interrogation. Your client kind of might be like, well, what do you think I am? But you have to ask this question. You have to be prepared. Immigration, it's amazing how much information they have, especially anytime you're put into secondary. This similar case, he had a friend who was put into secondary, and then all of a sudden the officer went through like the Facebook chat history between our client and the friend. The officer was like trying to insinuate that our client was bringing women over to Coachella as like almost a form of prostitution. But this is the first time it's ever happened to me, but it's amazing how much immigration knows about your client. And they I don't know if they have investigators, but they have Google Maps, and it's also the web is so easily, you can get so much information. And if your client's been put in secondary, or any of their friends, families, associates have been put in secondary, all that information on their phone is now in the possession of immigration, and now they have the ability to review that. So if, whether that's a habeas violation, all that stuff, I can't answer that right now. But preparation is the most important thing you can do with your clients. And as long as you have them prepared and you kind of calm them down, and you sort of get them to sort of be relaxed before the interview, usually it goes really smoothly. It could be a little scary sometimes. The officers, I think they want to make sure you sort of understand the seriousness of getting a green card or getting your citizenship. But as long as you're prepared, you're not hiding anything, you've reviewed with your lawyer everything, you've studied for your tests, you have provided them documentation, you have a good chance of being successful.
Thanks very much, Jonathan. And you've had a chance to be in immigration proceedings in person since the Biden administration took over. Have you noticed any kinds of changes on the ground?
Yeah, so procedurally speaking, obviously you do not need the I-944, which is great because that form is really tedious. So that is great. I went to one marriage interview recently. There was a big lag in terms of being called. We had to wait like 2 hours. I think so. In terms of the lag, I think it's still the same. I was just talking to Joanne about this beforehand. It was a little bit of an unorthodox interview where obviously you have all the different forms you have to file for a marriage case. You have your I-485, your I-130, your I-130A. And usually the officer goes through each question. This was kind of a unique experience where they just gave, he asked most of the questions on the I-485, but he didn't go through all the questions about, have you ever been a terrorist? You remember a Nazi party? I'd say it was a pretty quick review of that, that's weird because usually officers like to go through each question. And then for the I-130, which the I-45 is for the adjustment of status, the I-130 is essentially you are marrying a U.S. citizen, and he just gave the I-130 to both the U.S. citizen husband and the immigrant wife, and just said, all right, review this, and if there are any changes you want to make, go put it in a pen. And he kind of just like went to another room. So that was very unique. I never saw that in any other interview I've been in. Also, one more thing too, coronavirus stuff, obviously with all government buildings, different places have different procedures. Santa Ana was like very strict. You have to like first come, and you had to take your temperature and then obviously answer the 3 questions. Have you tested positive? Have you traveled? All that stuff. And then like we went into like 3 different rooms. 300 North. I think when you go to take your fingerprint, that's in the window. This is before you go to the officer. The person behind the window will ask you if you the 3 questions. I don't know if they're doing temperature checks. 300 North was a little bit scary. I don't know if anyone was paying attention to the immigration listserv, but there were a bunch of positive cases on the 8th floor. So I never had a interview canceled because of a positive case on the 8th floor, but I know colleagues who've had. And also when quarantine happened, pretty much everything shut down. So any pending citizenship case I had or marriage case was canceled. And that was probably going on for like a good month. I want to say around April 1st, maybe mid-April, USCIS started to reschedule interviews for citizenship and marriage cases, but it's still, obviously the quarantine continued the backlog, which was already so big.
Thank you for that update. We have a few minutes left. If there's any other questions for Jonathan and the upcoming changes or what's going on the ground, you can pop it up in the chat or you can put it in the Q&A. And while you're doing that, I'll just recap some of our upcoming plans. As Joanne had mentioned at the top, we're reigniting the immigration section here at BHBA. Joanne and I are co-chairing, and we've got a few plans lined up. We'd invite you to please join the immigration section. We're going to be meeting on the second Friday of every month at 12:30. And if you would like to be part of planning future panels, future events, we'd love to have you join us. Coming up in July, we're planning to have a panel on EB-5 and investor, immigrant, and non-immigrant visas featuring Ali Brody. And she's going to be bringing a colleague of hers in securities law. And so it'll be looking at both the immigration side and also getting some awareness and around the security side of foreign investors coming into the United States. So if that's something you're interested in or you've had questions about, we'd love to see you there. We're also teeing up, hopefully for June, a discussion around the intersections of criminal law and immigration law. And so that's an area, as Jonathan was just saying, you know, in advance of going to any interview, you're asking, you know, have you had any criminal issues, any family members with criminal issues? So understanding, you know, especially working with our criminal law colleagues and defense colleagues around what are the immigration consequences of arrests and convictions. It'll be a great opportunity to share information. And then looking forward, August or September, we're planning an update on the state of affairs of entertainment and immigration. And Jonathan, based on your background, I'm sure you'd be interested in what's going on, or you'd be able to share some experiences in the past year under COVID. You know, things like all matters have been a little bit turned upside down around the entertainment industry and moving people. And hopefully by the end of the summer, we'll have a clearer idea of where things are going now that there's, you know, better vaccination rates and fewer restrictions here in Los Angeles around COVID. So we'll be looking forward to doing an immigration and entertainment update later in the summer, August, September. I'm not seeing any questions, so I guess we'll be wrapping up. We've posted our contact information, links for joining the immigration section, links for joining the immigration community, and also this panel will be on YouTube. And as Joanne said at the top, we'll be sending out MCLE credits by email to everyone who registered within 24 hours. And I'll turn it over to Joanne to wrap things up.
Okay, great. Thank you so much, Jonathan, for that great presentation. And I think we all learned a lot and it was covered a lot of information. If anyone has questions that pop up later, you can email any of us. And if we don't know the answer, we will find a person to send your way. And yeah, so we hope you all join our section, and let's have some fun on Fridays and discuss crazy immigration issues and complain about our not so fun cases sometimes. Okay, thank you.